Can your child choose where they will live? Hi, I'm Alycia Kinchloe, the owner of Kinchloe Law, a family law practice based in the Philadelphia area. In today's video, I'm going to talk to you about whether a child can choose where they will live in a custody case. Now, this is the point of the video where I remind you that you want to speak with an attorney licensed in your state about the facts specific to your case, and that this video is for informational purposes only. When it comes to custody cases, generally a judge is going to want to speak with your child about certain things. Now, most judges will not directly ask a child where they want to live. One of the 16 factors in Pennsylvania that the courts must consider in custody cases is the preference of the child, but that does not mean that your child gets to choose where they will live. The judge will sometimes try to get at that particular factor by asking certain questions. And these questions can include things like, how is it at mother's house? How is it at father's house? What is going on there? And it may be specific questions about particular events that could have been raised during the custody proceedings. But the older the child, or the more mature the child, the judge will look at a little bit more of their preference. And the questions might seem to get a little bit more direct. In general, judges are going to start talking to children as young as 4 or 5, again, asking age and maturity and educational level-based and related questions regarding their particular living environments at each home and with each parent, or each party for that matter. And the older the child gets, like I stated before, those questions can get more direct and more mature, depending on the understanding and maturity level of the children. Now, when a child does get to be an older teenager, say around 14, 15, 16, the judges are looking heavily at what the child prefers. And sometimes it may not even come out as the judge asking directly, where do you want to live? But the child may offer that. And the older a child gets, the harder it is to keep them in one particular place. We know that it gets difficult to force a child to go with one parent or to keep a child in one place that they don't want to be. And then you start to run the risk of things like runaways, any type of delinquent behavior. So the court is going to be weighing those things along with the other factors they must consider. So sometimes parents will come to me with a child who's 8 or 9 and who they believe is very mature. And I understand that, children can be very precocious at young ages, but they still don't have the wherewithal to be able to consider, as we do in our adult minds, all the factors that need to go into determining what's in their best interest. And that is also why the preference of a child is just one of the 16 factors the courts must consider. So generally, the older a child gets, the more mature they are, their intellectual ability, those are all things that go into determining the child's preference and how much weight a judge may give to what a child may state is their preference. All right, I hope this video answers some questions regarding whether or not a child can choose. And whether a child chooses or say what they want, you need to understand it's just one of the 16 factors that must get considered. If you have any questions about this video, put it in the comments below. If there are any other topics you would like me to cover surrounding child support, divorce, or custody, please put it in the show notes as well. Make sure you hit subscribe and the notification bell so that anytime we drop a new video, you get a notification. All right, until next time, take care.